The Bogosity Podcast, early and ad-free. Become a subscriber at Patreon, Subscribestar, or Discord. Use the links at donate.bogosity.tv.
Welcome to the Bogosity Podcast for the week of October 13, 2024, the podcast that invented the carriageless horse. This is your host, Shane Killian. Let's beatify the news of the bogus. Starting off with another bit of fake news exposed, where NPR had to go back on a very misleading story about National Review's editor-in-chief Rich Lowry. And this calls back to the Trayvon Martin case, where the press made it sound like George Zimmerman used a racial epithet in a 911 call. Although the word, as any audio clarification tool can reveal, was cold, referring to the temperature that night, the press primed the audience to make the low-quality 911 call sound like he said another C word to refer to Martin's race. Lowry appeared on the Megyn Kelly show, and when he started to say the word migrants, he started to pronounce it like immigrants, but leave off the phoneme M. Then corrected himself, just like all of us do several times a day. Here's what it sounded like.
I think it was in that interview where Dana Bash says, the police have gone through 11 months of recordings of calls, and they've only found 2 Springfield residents calling to complain about Haitian migrants taking geese from ponds. Only 2 calls. And I think one lesson of this whole story, people don't care about geese. People really hate geese. They all things considered, yeah. I think people would prefer Haitian migrants to come and take the geese off the golf course, right?
Especially if you see it on the video. His lips are closed to make an M sound, not an N. But if you're primed to think it was an N sound, and therefore he started to say a racial epithet, then that's where your brain goes. So if your exposure to the audio was a tweet from Madeline Peltz of Media Matters for America, that very same group Elon Musk and X-Corp are suing for just this kind of crap, your brain is primed to hear the N-word. It goes back to what this podcast's parent series showed with electronic voice phenomenon. By priming the listener's ear to hear a certain phrase, you can make them hear it even if what they're listening to is complete noise. A more recent version of this is called the Green Needle Brainstorm, where a piece of audio went viral because people kept debating whether a children's toy was saying green needle or brainstorm. For most people, they can make themselves hear one or the other, like the duck rabbit illusion. But like EVP and like this tweet, with your brain primed to hear one or the other, that's the one it hears. Your brain is constantly working to make clarity out of a noisy world, and dishonest people like Peltz exploit that all the time. So NPR ran the story with the headline, Conservative Editor-in-Chief appears to use racial slur to refer to Haitian migrants, leaving out all of the important context that would lead readers to the truth. After the story was published, NPR's own editorial team reviewed the story. Why they didn't do it before publication is a serious question that needs answering, but they found that it didn't meet the standards for fairness and accuracy. They edited the article and changed the headline to read, Conservative Editor-in-Chief says mispronunciation led to accusations of using slur. However, they didn't issue any clarification note or correction on the story, just stealth editing so that Minitrue can pretend that was the story all along. Lowry called the original headline grossly unfair and misleading and said that while he appreciated the revisions, the story should never have been published in the first place. NPR bypassed their own standards to lend credibility to a baseless viral accusation. Ava Rodriguez, vice president and executive editor for NPR, defended the story, calling it of significant public interest, and standards editor Tony Caven claimed there were no factual inaccuracies in the original report. On the other hand, NPR media correspondent David Folkenflik doubted the newsworthiness of the story and said, quote, "I think people should be dinged for and reported on what they actually do." Yeah, but if they did that, then what would they have left to publish?
Sometimes you just have to stomp some skulls. From the mind of Mr. Dapperton, a game for the ages. In a world where a race of undead furries tries to take over the world's nuclear arsenal, one man must stop them. But which man? You choose. Dapperton, Elon,
not my Dogecoins,
Joe,
build me back,
Shapiro,
my kippa's ruined,
or Don John.
ow, my ear.
Forget those losers. You know you want to play as me, Lord Killian. That's right. You can stomp the skulls of those commie furries and save the universe as me.
7 complete different worlds with more coming all the time. Full controller support. You can even get eaten by a worm and pooped out into a furry cathedral. You know you want this game. Go to links.bogosity.tv/skullstompers and play Skull Stompers now.
So we've been covering the astounding failure of the lawfare against Donald Trump to try and get some kind of negative ruling against him before the election. They've all basically fallen apart. The Georgia case is effectively dead because of major prosecutorial misconduct. He won't see sentencing in the New York case, and attempts to have him declared an insurrectionist without a trial failed in several states. The biggest case that was said to be against him was the classified documents case, the one they raided Mar-a-Lago over. That case was dismissed because Jack Smith isn't a real prosecutor. Under the Constitution, federal prosecutors, including special prosecutors, have to be appointed by the president and confirmed by the Senate. That didn't happen with Smith, and so the case went away. However, the Jan 6 case in D.C. is still going on, because although the prosecution is headed by that self-same Jack Smith, as we've covered, the judge, Tanya Chutkan, is unbelievably corrupt and biased and has permitted several things that would have gotten any other case dismissed with prejudice. What stopped it was an interlocutory appeal which went to the Supreme Court. Because basically everything they accuse Trump of doing is a part of his presidential powers. Things like investigating allegations of election crimes, having meetings with his staff, even talking to his vice president. As we covered, the Supreme Court smacked it down and said, of course all of this is immune. Didn't you read Marbury v. Madison, you idiotic jerks? Okay, they were more polite than that, but that was the gist. So then, Smith had to go through and take out all of the immune stuff. But since that would have left him with nothing, what he actually had were excuses as to why the stuff wasn't immune after all. And Chutkan allowed Smith to do something that basically no prosecutor has ever been allowed to do before. Check out this Intelligencer article from Ellie Honig, former federal prosecutor, now CNN legal analyst. The first issue is how massive the brief is. Chutkan gave him permission to file a 180-page brief, 4 times the normal maximum. Honig is a never-Trumper, by the way, and that's why we get passages like, "We now have damning new details on Trump's effort to pressure Vice President Mike Pence to throw the election his way. Trump's phone use and use of Twitter as the riot unfolded, and his conversations with family members about efforts to contest his electoral loss." Except, we don't. All of this is what we knew before, and it was a big meh. He says, "The story structure is the same as we've long known, but the new details lend depth and dimension." But they really don't. But his criticism of Smith is as spot on as it is unrestrained. Quote, "The larger, if less obvious headline is that Smith has essentially abandoned any pretense. He'll bend any rule, switch up on any practice, so long as he gets to chip away at Trump's electoral prospects. At this point, there's simply no defending Smith's conduct on any sort of principled or institutional basis. But we need to know this stuff before we vote is a nice bumper sticker, but it's neither a response to nor an excuse for Smith's unprincipled, norm-breaking practice. It also overlooks the fact that the Justice Department bears responsibility for taking over 2.5 years to indict in the first place. He talks about how the legal process has been turned entirely on its head. Quote, "The way motions work, under the federal rules and consistent with common sense, is that the prosecutor files an indictment, the defense makes motions to dismiss charges, to suppress evidence, or what have you, and then the prosecution responds to those motions. Makes sense, right? It's worked for hundreds of years in our courts. Not here. Not when there's an election right around the corner and dwindling opportunity to make a dent." So Smith turned the well-established, thoroughly controversial rules of criminal procedure on their head and asked Judge Chutkan for permission to file first, even with no actual defense motion pending. Trump's team objected, and the judge acknowledged that Smith's request to file first was procedurally irregular moments before she ruled in Smith's favor, as she's done at virtually every consequential turn. And the filing is completely prejudicial. Quote, "It's ironic. Smith has complained throughout the case that Trump's words might taint the jury pool. Accordingly, the special counsel requested a gag order that was so preposterously broad that even Judge Chutkan slimmed it down considerably, and the Court of Appeals narrowed it further after that. Yet Smith now uses grand jury testimony, which ordinarily remains secret at this stage, and drafts up a tidy 165-page document that contains all manner of damaging statements about a criminal defendant made outside of a trial setting and without being subjected to the rules of evidence or cross-examination, and files it publicly, generating national headlines. You know who'll see those allegations? The voters, sure, and also members of the jury pool." And hey, remember when Comey said he wasn't going to indict Hillary even though she was guilty as sin? That was because of a long-standing practice that apparently no longer applies. Quote, "The Justice Manual, DOJ's internal Bible essentially, contains a section called Actions that May Have an Impact on the Election. Now, does Smith's filing qualify? May it have an impact on the election? Of course. So what does the rule tell us? Federal prosecutors may never select the timing of any action, including investigative steps, criminal charges, or statements, for the purpose of affecting any election. Remember, Smith begged the judge to flip the rules on their head so he could file this document first and quickly, any action by any reasonable definition, with the election right around the corner. There's another big problem here that Honig doesn't mention. Listen to Honig himself talk about Smith's approach on CNN.
There's a quote in here from Jack Smith that I think sums up his approach very well. He says, quote, "The through line of Trump's efforts was deceit. The through line of these efforts was not doing his job as president. He was acting deceitfully." So Jack Smith here, this is his brief, and he's saying to Judge Chutkan, all the stuff that's in our new slim down indictment, it's all okay. None of it is entitled to immunity, and we should be able to proceed to trial on it.
But deceit is all about intent. Yet the Supreme Court specifically said they couldn't consider intent when determining if presidential actions were immune or not. But that's exactly what Smith did. And Honig didn't seem to mention that part. But it's just what you might expect from a DOJ that deliberately waited 2.5 years to bring this case forward, only to try and rush it into place before the election. Of course, the story you get from the media is that it's Trump who's delaying things, but that's every bit the fake news as our first segment was. Don't trust the news media. Don't trust social media. Trust in the methods of rationality. It's a lot of work, but it's the only way to navigate the travesty of journalism this past 10 years or so. If you're on the Wi-Fi in a coffee shop or hotel, anyone on that network can get your traffic. Do you really trust all of those strangers? For that matter, do you really trust your ISP? A VPN can protect you from prying eyes, disguise your location, and even foil government censors. It's essential in this day and age, so go to vpn.bogosity.tv and you'll be taken to BoxPN. Starting at just $2.99 a month, you can get unlimited high-speed connections to VPN servers all over the world, and they don't log connections, so your privacy is assured. Traveling abroad, just VPN home, and don't worry about what those other governments are doing. Back at home, stop your ISP from traffic shaping and messing with the quality internet access you're paying good money for. You can connect from multiple machines at once, including your smartphone or tablet, and it supports all the secure standards, including OpenVPN and SSTP. Bypass censors and surveillance with your own secure VPN connection. Go to vpn.bogosity.tv. All the fake stuff wouldn't be so bad if people could voice the opposition to it. But again and again, we see opposition voices being censored. Remember when the internet was free? You could say all sorts of ridiculous and cockamamie things and not be censored for it. If you didn't have the time to use the methods of rationality on everything you heard, you'd be left not knowing what to believe. But that's a much better situation than it is now, where for most people the only thing they're given to believe is the ridiculous and the cockamamie. That's the thing about censorship. Truth never fears alternative voices. It's only the peddlers of bogosity who have to engage in it. History has shown that time and time again. Fortunately, albeit slowly, more and more this is being exposed. Unlike Twitter, which was pretty much dumped on us in the Twitter files, we've been getting a slow trickle about the role the U.S. government has been playing in censorship of videos on YouTube. So House Judiciary Committee Chairman Jim Jordan did what he does best and sent them a letter. That ought to show him. The committee has expanded its investigation into big tech censorship and its ties to the intelligence community. Specifically, they're wondering why YouTube blocked an interview with FBI whistleblower Marcus Allen. Allen is one of the biggest voices trying to expose how many confidential informants were present on J6. We know it numbers in the dozens. What isn't known is the total amount and how many of them were the instigators of the breach of the Capitol building and subsequent riot. The FBI illegally retaliated against him, including revoking his security clearance, which the committee forced them to restore along with his back pay. The FBI also targeted him for his religious beliefs. Allen is a devout Catholic. So the nonprofit group Catholics for Catholics had him on their channel on September 29, and YouTube promptly blocked it. Jordan's letter reads, "The committee has obtained documents showing that the federal government successfully pressured YouTube, a subsidiary of Alphabet, to censor certain content, including content that did not violate YouTube's content moderation policies. Now, YouTube appears to have censored a video in which FBI whistleblower Marcus Allen, a witness before the Select Subcommittee, detailed serious misconduct of the FBI and expressed his deeply held religious beliefs. This censorship of religious and political speech is deeply troubling in light of YouTube's previous collusion with the Biden-Harris administration and Alphabet's pattern of anti-conservative political bias. YouTube banned the video for, quote, violating YouTube's community guidelines without any further explanation, as they do. Quote, at every juncture, the Biden-Harris administration has sought to silence Mr. Allen. The FBI wrongly suspended him without pay due to his personal medical decisions, his religious beliefs, and for questioning FBI leadership. The FBI even went so far as to baselessly question Mr. Allen's allegiance to the United States, despite his many years of exemplary service to our country. At the September 25 hearing before the Select Subcommittee, DOJ Inspector General Michael Horowitz said that the details of Mr. Allen's case illustrate many of the concerns and systemic issues that we have seen with the security clearance process. Given the past misconduct of the FBI and YouTube, YouTube's censorship of an FBI whistleblower story and religious speech is particularly troubling. The committee wants YouTube to answer questions as to why the video was removed. Was the removal automated or manual? What protections does YouTube have for religious speech, and why did they not apply here? Who's responsible for making this determination? And what communications did YouTube have with the Biden-Harris administration before or after the video? All of this is part of the continuing subpoena the committee has had against Alphabet since February 15, 2023, and they requested the documents to be provided to them no later than 10 a.m. on the 21st. It's high time this was put a stop to. And while getting Biden-Harris out of the White House might improve things, it won't solve them, as this problem started long before they got in. It's due to the rot that runs throughout the IC. And if Trump's at all serious about draining the swamp, those are the first people he should go after should he be reelected. Personally, I'm not holding my breath, but at least there's been a light shown on them. Do you have children, or nieces or nephews? Are you homeschooling, or just want to counter some of the socialist indoctrination most children get in school? If so, go to bogosity.tv/TuttleTwins, and you'll be taken to a website where you can get some great books for elementary-aged children. The Tuttle Twins books are books about liberty and free market economics that include children's versions of Bastiat's The Law, Leonard Read's I, Pencil, and Hayek's The Road to Serfdom, as well as books about the Federal Reserve and how regulations protect business cronies. They'll learn about the harm caused by eminent domain, or regulations passed in the name of safety, and fundamental concepts of liberty. And as you can see from the sample pages on the website, they're all easy to read and nicely illustrated. They're just $9.99 a piece, or get a special discount as well as free bonuses when you purchase all 5. You can even buy in bulk to donate to schools and local libraries. So get the Tuttle Twins books at bogosity.tv/TuttleTwins. And now it's time to transcendentalize this week's biggest bogon emitter. And this week it goes to Apple for more App Store shenanigans. This time with music streaming app Musi. Musi streams music from third-party sources, including YouTube. Apple removed Musi because of a YouTube complaint, and the company has filed suit claiming this is a breach of contract. Their suit also raises unanswered questions about YouTube's copyright claims. Musi has millions of users, so naturally the music industry wants it taken down. Heaven forbid they should actually make an app themselves that people like. But they call Musi parasitic and have stopped one step short of calling it a piracy app. None of the parties have given any details as to why the app was removed. Musi has sued Apple for breach of contract and breach of implied covenant of good faith and fair dealing. They claim, despite its obligations to investigate complaints in good faith, Apple removed the Musi app based upon unsupported accusations from a third party who has failed to respond to Musi's communications. Worse, Apple was fully aware that the third party had failed to substantiate its claims to Musi. Apple's improper removal of the Musi app has caused, and continues to cause, substantial harm to Musi's business and reputation. They kept trying to contact Apple to understand the basics of the complaint and never received a reply. Quote, Musi, on the other hand, has promptly responded to all of Apple's communications regarding the complaint. Even more concerning, in April and May of 2021, Musi engaged with outside counsel for YouTube, apparently the same complainant, to address several questions YouTube had about the functionality of the Musi app and compliance with the YouTube terms of service. Musi substantively addressed YouTube's concerns, but heard nothing further from YouTube until several years later in March 2023 and July 2024, when YouTube sent a standard notice to Apple stating that the Musi app violated its intellectual property rights without any explanation. Musi again contacted YouTube to address its concerns without receiving any response. Apple nonetheless suddenly and unjustifiably removed the Musi app from the App Store on the basis of the July 2024 complaint. To date, the Musi app has not been restored. The removal was all the more galling in light of the fact that Apple threatened to remove the app if Musi did not try to resolve the alleged complaint with the complainant, and Apple was fully aware that the complainant had elected not to communicate in any way directly with Musi. The only complaint YouTube made in its communication was, quote, violating YouTube terms of service with no further details. YouTube is known to take action against software that abuses its API to offer competing services, but Musi says they don't use YouTube's API. YouTube sent an email to Apple saying, quote, "We are writing to follow up on this matter. Musi has not reached out to us despite their message below, and this app continues to violate our terms of service. We request that you please proceed with removing this app from the App Store." But Musi pointed out that they had contacted YouTube. YouTube was the one that didn't respond to them. Despite this, Apple removed the app. Quote, "Apple's decision to abruptly and arbitrarily remove the Musi app from the App Store without any indication whatsoever from the complainant as to how Musi's app infringed complainant's intellectual property or violated its terms of service, and in light of the fact that Musi has continued to operate the Musi app in a substantially similar manner since May 2021, was unreasonable, lacked good cause, and violated Apple's development agreement's terms. Apple's decision has caused immediate and ongoing financial and reputational harm to Musi. Without the court's immediate intervention, Musi and consumers face irreparable damage. And the sneakiest part of all of this is that YouTube was able to do it all without actually suing Musi. They're demanding a jury trial. In the interim, they're asking the court for an injunction to require Apple to restore Musi in the App Store. Abuse of their app stores by Apple and Google is an increasing problem, especially regarding apps that operate legally yet compete with the tech giants. And what's at stake is any app that legally uses publicly available content, especially when it's not doing anything a web browser or a search engine couldn't do, just with a much better interface than YouTube can seem to come up with. And contracts certainly can't be broken with the equivalent of a toxic girlfriend saying, "Well, if you don't know, I'm certainly not going to tell you." And you shouldn't have to engage in an expensive lawsuit to find out. So all of that makes Apple this week's biggest bogon emitter. I want to tell you about the eyeglasses I've been wearing for years. As people can see on my videos, I have a very strong prescription, which makes glasses more expensive, especially when I need computer glasses, reading glasses, prescription sunglasses, and most expensively, progressive lenses for general everyday wear. To save money while still getting quality glasses, I get them from Firmoo. In fact, I just got a pair of progressives with high-index aspherical lenses and a nice pair of frames my wife loves for just over $100. It would have been $500 to get them through my eye doctor. Not only do they look good, the glasses are durable. I've worn many pairs for several years without problems. All orders come with a 30-day return policy, a 3-month warranty, and one-on-one customer service. Go to Firmoo, that's FIRMOO.Bogosity.tv anytime you need quality glasses at a low price. Once again, that's Firmoo.Bogosity.tv. And now let's unnecessarizationify this week's Idiot Extraordinaire. And this week it goes to the Haitian Bridge Alliance and their law firm for an absolutely ridiculous bit of lawfare against Donald Trump and J.D. Vance. Yeah, this is about the whole eating the dogs thing. But to misquote Evelyn Beatrice Hall, I think what you said is as dumb as mule farts, but I'll defend to my last breath your right to say it. If your fifis have been hurted by someone's words, you are free to lash back with words of your own. But you cannot try and put them in jail for it. But that's exactly what the Haitian Bridge Alliance did, thanks to a quirk in Ohio law. Their state statute RC 2935.09 paragraph D says, quote, "A private citizen having knowledge of the facts who seeks to cause an arrest or prosecution under this section may file an affidavit charging the offense committed with a reviewing official for the purpose of review to determine if a complaint should be filed by the prosecuting attorney or attorney charged by law with the prosecution of offense in the court or before the magistrate." In other words, private citizens can file charges as though they were prosecutors. Hey, it makes him more of a prosecutor than Jack Smith, I guess. Of course, you have to get it past a judge, and that's not very likely if your complaint is about First Amendment protected speech. Understand, this is not a defamation lawsuit. This is a criminal complaint that threatens fine and imprisonment. In fact, they charge them with 2 felonies and 7 misdemeanors. And if you're wondering what merit this could possibly have, well, so were the judges. Quote, all of the conduct alleged in the affidavit centers around the statements made by either Donald Trump or J.D. Vance. Freedom of speech is among our most precious and protected constitutional rights. It is enshrined in the First Amendment of the United States Constitution. Indeed, the United States and Ohio Supreme Courts have recognized the importance of speech even when it stirs people to anger. In this case, not only do the allegations raise the issue of speech, but complain of political speech. Political speech is at the core of what the First Amendment is designed to protect. They cited several cases, including Morse v. Frederick, Virginia v. Black, Citizens United, FEC v. Wisconsin Right to Life, Sorrell v. IMF Health, and several others. The main one, of course, is Brandenburg v. Ohio, which, as longtime listeners know, defined the limit of criminal action against speech as the eminent lawless action standard. And note that nowhere in the Brandenburg test is how other people respond to the speech. You're only responsible for your actions, not the actions of others. They ruled, although all speech does not have absolute constitutional protection, the strict scrutiny analysis of any criminalization of speech requires thorough and extensive investigation before any charges will be pursued. Due to the proximity of the election and the contentiousness concerning the immigration policies of both candidates, the court cannot automatically presume good faith nature of the affidavits. In their complaint, they allege that all sorts of horrible things happened to them because of what Trump and Vance said. However, quote, in this case, the conduct referred to is speech. For probable cause to exist, it is not sufficient that Trump or Vance might have foreseen the acts by others that are alleged in the affidavits. So they ruled, because the court questions the existence of probable cause and the good faith nature of the affidavits, the court is required to refer the felony charges to the appropriate prosecuting attorney for further investigation. Therefore, this court cannot dismiss the affidavits and its requests in their entirety. And the concurrence by Stephen Schumacher is even more intensely critical. Quote, the affiance materials rely heavily on statements by Governor DeWine and local officials to attempt to establish probable cause of the false nature of the statements. The statements from the officials repeatedly indicate the following very similar statements. We wish to clarify that we have not been able to verify any credible reports. They found no credible evidence. They have no evidence of that at all. No verifiable evidence or reports to show this was true. We just have no verifiable claim that this actually happened, and many similar statements. There is nothing in the reported statements by the officials that, on the basis of the record before the court, would justify any opinion that the statements at issue are false, just that they cannot be verified as true. Wow! A lesson in basic logic! I think I like this judge. He also gave them a lesson in quote mining, since they had brought up for support the create stories misquote. He wrote, the court has reviewed that recording numerous times. The court sees nothing in the interview that is an admission by Senator Vance that he was just making harmful statements up. When the interviewer questioned him about creating stories, the senator immediately replied, Dana, it comes from first-hand accounts of my constituents. I say we are creating a story, meaning we are creating the American media's focus on it. The interviewer later says, I have not accused you of anything. And you just can't arrest people based on that. You need to find actual malice, that you knew or should have known it was false or had a reckless disregard for the truth. Quote, the court considers the affiance of Ehrman in paragraph 52 and paragraph 7 to be inaccurate and misleading. The evidence submitted in the above listed paragraph/exhibits on the flash drive is, if anything, exculpatory, as the exhibits tend to exonerate former President Trump and Senator Vance of the requisite mens rea in the allegations. The evidence submitted by the affiant tends to show that former President Trump and Senator Vance relied upon reports made to them by constituents. the affiant bears the burden of production/proof to establish probable cause. The above listed evidence tends to negate probable cause as to the element of the mens rea required in the requested charges. Speculation does not establish probable cause. They claim that their statements resulted in 33 bomb threats, but as Schumacher pointed out, they give no information except that they were all hoaxes and show no causation other than they just happened to be in proximity to the statements. For those and other reasons, the court found that there was no probable cause and no merit to the charges. To quote the late great Ron Popeil, "But wait, there's more." He also lambasted them for not filing the action in good faith. Quote, "The language used to advocate for the action is troubling to the court. As noted in the court's decision, the evidence produced does not even establish probable cause that the statements are false, much less lies. The court, as noted in this decision, is particularly concerned about counsel and the affiant statements that Senator Vance admitted just making harmful statements up. The court considers this to be a significant mischaracterization of the evidence submitted to the court. The court finds that this judge has reason to believe that it was not filed in good faith. The court also finds that the claim is not meritorious. Both findings are for the reasons set forth in this concurring opinion. Having made the above findings, Ohio Revised Code Section 2935.10 leaves this court with only one option. The court hereby refers the matter to the Clark County Prosecuting Attorney for investigation. This is one very important fact to keep in mind. The media is making out like the court referring it to prosecutors means it's totally credible. No, they lambasted it from start to finish, and the only thing they could do other than support it was refer it to prosecutors for further investigation. This is absolutely a loss for the alliance, and the judges handed them their asses. Given that this is absolutely 100% First Amendment protected speech, there's basically no chance any prosecutor is actually going to pick it up and do anything with it. Now, after all that, the question is, what sort of shyster law firm picked that up to begin with? And the answer is the Chandra Law Firm, and being told off on basic constitutional law has gotten their little panties in a bunch, so much so that they just had to post an article to their website blasting the judges. Lead counsel Subodh Chandra wrote, "Our clients were concerned when the court made up a special procedure just to handle this case. Instead of doing what one might ordinarily expect of a court, which is to have the clerk's office assign the matter by random draw, the court referred the matter to all the judges. That's not only generally unheard of for a trial court, it diffuses individual judicial responsibility. It also affords special treatment for Donald Trump and J.D. Vance that no other citizens will be afforded." How is this special treatment? You got the entire panel to hear your complaint and didn't convince a single one of them. What do you think any of them individually would have done? Quote, "The concurring opinion seems to rely on a fatal shrug about whether Trump and Vance really caused the harm to Springfield. But the law permits people to rely on circumstantial evidence and inferences." Not when it's protected by the First Amendment, you morons! You have to survive strict scrutiny, not just make inferences. Quote, "The decision is condescending and cruel to Haitian immigrants. The concurring opinion seems to pretend that somehow it's a coin toss as to whether Trump's and Vance's lies about Haitian immigrants are true and whether the governor, mayor, and city manager truly said those lies are false." That is not at all what he said. Did you fail the basic logic lesson he gave? It wasn't 50-50 or anything. You had no evidence whatsoever that they were false, let alone lies. Probable cause isn't even 50-50. That's the preponderance of evidence standard. Probable cause is a much easier standard to make, and you couldn't make it. Quote, "Because prosecutors haven't acted to protect the Springfield community from Trump's and Vance's relentless falsehoods about the Haitian community, the bridge is skeptical about whether they will do so now." Yeah, so are we, sunshine. So are we. Remember, they're trying to have their political opponents arrested for speech. If anything, it's these lawyers who should have action taken against them, say against the bar, for wasting the court's time and, as Schumacher said, quote, "It took many hours to adequately review and consider the points made." For something as blatantly unconstitutional as this is misconduct and malpractice, plain and simple. At the very least, the court should sanction them for wasting the court's time and the taxpayers' money. So all of that makes the Haitian Bridge Alliance and the Chandra Law Firm this week's
Idiot Extraordinaire.
Well, that wraps up this One Has No Wish to Be Devoured by Alien Monstrosities, even in the cause of political progress edition of the Bogosity Podcast. I hope you enjoyed it. If you did, please go to donate.bogosity.tv for several ways to support and discord.bogosity.tv to join the discussion. Subscribe at the Discord or at Patreon or Subscribestar, and you can listen early and ad-free. Thank you for listening. Until next time, here's a quote from Hans von Spakovsky. "Whether they're right or wrong is irrelevant. They have a First Amendment right to speak out, even if they are wrong. And to criminally prosecute individuals for doing that is a violation of the First Amendment." The Bogosity Podcast is licensed under Creative Commons Attribution Non-Commercial No Derivatives 4.0 International License.
Bogosity.